Many foreign investors believe that the biggest risk in a joint venture in Vietnam lies in the contract itself. They focus on negotiating terms, reviewing clauses, and finalizing agreements. But in reality, the most critical mistake often happens before any document is signed. It is choosing the wrong partner without proper legal and structural verification. In Vietnam, this mistake can be difficult and costly to fix later. Foreign investors entering Vietnam often rely on local partners to navigate regulatory requirements, market access, and operational challenges. In many sectors, a joint venture with a local partner in Vietnam is not just strategic, but necessary due to foreign ownership restrictions. While local partners can provide valuable support, they also introduce risks that must be carefully assessed before signing any joint venture agreement in Vietnam. One of the first elements foreign investors should verify is the legal capacity of the local partner. Not every company or individual has the authority to enter into a joint venture agreement in Vietnam. Issues such as incomplete licensing, restricted business lines, or internal ownership disputes can affect their ability to participate. Without proper legal due diligence, you may enter into an agreement that cannot be fully enforced. Understanding the ownership structure of your local partner is critical. In some cases, the apparent shareholder is not the real decision maker. Complex structures involving multiple entities or individuals can create uncertainty. For foreign investors in Vietnam, this lack of transparency can lead to situations where control is exercised by parties who are not formally part of the joint venture agreement. One of the most overlooked risks in Vietnam is the nominee structure. A local partner may be acting on behalf of another party, or may themselves be part of an informal arrangement. This creates a disconnect between legal ownership and actual control. For foreign investors, entering a joint venture without identifying nominee risks can result in loss of control or inability to enforce agreements. Financial capacity and transparency are equally important. A local partner may appear strong based on reputation, but without verified financial information, their ability to contribute capital or support operations may be uncertain. A joint venture agreement in Vietnam often includes capital contribution obligations. If your partner cannot fulfill these obligations, the entire structure of the investment may be affected. Many disputes in joint ventures in Vietnam originate from misaligned expectations before the agreement is signed. Differences in business goals, risk tolerance, and management style can create tension. If these issues are not addressed early, they will not disappear after incorporation. Instead, they will become embedded in the joint venture agreement and lead to conflict during operations. Foreign investors are often under pressure to move quickly in competitive markets. However, speed should not come at the expense of proper due diligence. Verifying your partner's legal status, ownership structure, and financial position is essential before entering a joint venture in Vietnam. A well-structured joint venture agreement cannot compensate for a fundamentally flawed partnership. At LTS Law, we provide legal services for foreign investors in Vietnam by conducting partner due diligence and advising on joint venture structures before any agreement is signed. We help identify legal risks, assess ownership structures, and ensure that your joint venture agreement in Vietnam is built on a reliable foundation. Our approach focuses on prevention rather than correction. A joint venture in Vietnam is not just a legal arrangement. It is a long-term business relationship. Before signing any joint venture agreement in Vietnam, make sure you fully understand who you are partnering with. Visit lts.com.vn and consult with our legal team to ensure your investment starts with clarity, not uncertainty.